Before we begin, a quick and important disclaimer. The following content is provided strictly for educational and entertainment purposes and does not constitute legal advice, professional counseling, or a substitute for the services of a licensed attorney. Laws regarding domestic relations, equitable distribution, and matrimonial actions vary significantly by jurisdiction and have evolved drastically over the centuries. Viewers are strongly encouraged to conduct their own due diligence and consult with a qualified legal professional regarding any specific personal or legal matters. This analysis is a historical and sociological deep dive into the evolution of a profession and the statutes that shaped it. Imagine a city where the only way to escape a marriage was to prove your spouse committed the ultimate betrayal in a public courtroom, with details so lurid they became the breakfast table gossip of millions. In New York City, for nearly 2 centuries, this wasn't just a possibility. It was the only legal reality. For 183 years, New York held the title of the most restrictive divorce jurisdiction in the Western world, maintaining a legal fortress that essentially required a private investigator, a staged photograph, and a public trial just to sign a piece of paper. This is not just a story of legal statutes. It is a historical analysis of how the New York City divorce lawyer evolved from a shadowy figure of the Gilded Age to one of the most powerful and influential architects of modern American society. We are uncovering the secret history of the holy deadlock, the rise of the migratory divorce, and the multi-billion-dollar industry that literally had to reinvent the definition of love to survive. This deep dive masterclass solves a critical problem for anyone trying to understand the current American social and legal landscape. How did we get from a world of fault-only morality to a no-fault economy? By the end of this analysis, you will understand the historical trends that shape the modern family, the case studies of high-stakes Gilded Age separations that set the precedent for today's celebrity splits, and the specific evolution of New York's domestic relations law that turned the Empire State into the final holdout of traditional matrimonial warfare. The era of the single ground, 1787 to 1966. To understand the modern New York divorce lawyer, we must first go back to March 30, 1787. On this date, the New York State Legislature passed a law that would remain virtually unchanged for almost 200 years. It established that adultery was the sole statutory ground for an absolute divorce. If your spouse was abusive, if they abandoned you, or if they were a habitual drunkard, the law essentially told you to stay put. This created a unique and often desperate environment for legal practitioners. In the 19th century, the divorce lawyer was not the prestigious title it is today. Often, these attorneys operated in the fringes of the legal community. Because the burden of proof was so high, the lawyer's job wasn't just to argue law. It was to manage evidence that was nearly impossible to get. Historical trends show that this restriction did not stop people from wanting to end their marriages. It simply forced them to get creative or criminal. During the Gilded Age, the stakes for New York's elite were astronomical. Take the case study of Alva Vanderbilt in 1895. Alva, a social titan, did the unthinkable by suing William Kissam Vanderbilt for divorce. At the time, even for the wealthiest families, the social stigma was a social death. Her lawyer had to navigate the strict adultery-only rule while maintaining Alva's reputation. Alva's success in obtaining a divorce, a $100,000 annual stipend, roughly $3.5 million today, and custody of her children was a seismic shift. It proved that with the right legal architect, even the most rigid laws could be navigated by those with enough resources. The rise of the divorce colony and migratory law. Because New York was so restrictive, a fascinating historical phenomenon emerged: the migratory divorce. For those who couldn't prove adultery or didn't want the public shame of a trial in Manhattan, the solution was to leave. This created a competitive market where other states loosened their laws to attract New Yorkers' money. In the early 1900s, Sioux Falls, South Dakota, and later Reno, Nevada, became divorce colonies. New York lawyers often acted as travel agents for their clients, advising them on how to establish residency in Reno for 6 weeks to get a quickie divorce. However, this created a massive legal mess back in NYC. The 1906 Supreme Court case of Haddock versus Haddock highlighted the potential outcomes of this strategy. The court ruled that New York did not have to recognize a divorce granted in another state if the spouse stayed behind in New York. This meant a person could be legally divorced in Nevada but still married in New York, a state of legal limbo that kept NYC lawyers busy with bigamy by mistake cases for decades. The renovation of the profession. By the 1940s and 50s, the New York divorce lawyer had become a master of the annulment loop. Since divorce was too hard, lawyers turned to annulment, which required proving the marriage was void from the start due to fraud. Attorneys would argue that a spouse lied about wanting children or lied about their religious devotion. This was a legal fiction that everyone, the judges, the lawyers, and the clients, participated in just to bypass the 1787 law. Data from the 1960s shows a staggering disparity. While the national marriage-to-divorce ratio was 4-to-1 in New York, it was 17-to-1. This wasn't because New Yorkers were more happily married. It was because the legal barriers were so high that 60% of New Yorkers seeking divorce were forced to go out of state. The profession during this era was defined by this shadow law. Lawyers were essentially managing a black market of marital dissolution. The 1966 reform and the 6 grounds. Everything changed with the Divorce Reform Law of 1966. For the first time in nearly 2 centuries, New York expanded its grounds beyond adultery. The new list included cruel and inhuman treatment, abandonment for a period of 2 or more years, imprisonment for 3 or more consecutive years, living apart for 2 years pursuant to a separation decree or agreement. This shift transformed the NYC divorce lawyer from a private investigator coordinator into a complex litigator. The 1967 effective date of this law led to a flood of filings. It allowed for the conversion divorce, where a lawyer could draft a separation agreement, and after a waiting period, it would naturally become a divorce. This introduced the concept of negotiation over litigation, a trend that defines the industry today. However, even after 1966, New York remained a fault state. You still had to blame someone. It wasn't until October 2010, just 14 years ago, that New York finally became the very last state in the Union to adopt no-fault divorce. This historical delay created a specific New York style of matrimonial law: aggressive, detail-oriented, and deeply rooted in the financial complexities of Manhattan real estate and Wall Street assets. As we move forward in this analysis, we will look at how the 2010 no-fault revolution didn't actually make lawyers less necessary. It simply shifted the battlefield from who did what to who gets what. The modern New York divorce lawyer now operates in a world where equitable distribution is the new frontier, managing portfolios that include everything from crypto assets to rent-stabilized apartments. We are just scratching the surface of how a 1787 law against adultery built a 21st century legal empire. To understand how we transition from the rigidity of the 18th century into the sophisticated financial warfare of 2026, we have to examine the dark age of the professional correspondent. Imagine if you were a successful merchant in Manhattan in 1920. Your marriage has disintegrated not because of a scandal but because of simple incompatibility. In the eyes of the New York Supreme Court, that reason was legally non-existent. You were trapped. This desperation gave birth to a specialized, albeit ethically murky, wing of the legal profession, the architects of the staged raid. Historical trends from the early 20th century show a massive surge in what historians now call the divorce mills of New York. Because adultery was the only key to the golden cage, lawyers had to facilitate the production of evidence. This wasn't a secret, it was an industry. A lawyer would hire a professional witness, often a young woman known as a correspondent, whose entire job was to be discovered in a hotel room with the husband. There was no actual intimacy. The goal was a photograph or a witness testimony of the husband in a state of undress with a woman who was not his wife. Case studies of these staged raids reveal a meticulous step-by-step process. First, the attorney would coordinate with a private investigator. Second, a hotel room would be booked at a reputable establishment like the Hotel Pennsylvania or the Waldorf Astoria. Third, at a prearranged time, the investigator and the lawyer would burst into the room to find the husband and the hired woman. This created a bizarre legal theater. Judges often knew the evidence was manufactured, but because the paperwork was in order, the divorce was granted. It was a system built on a foundation of perjury, sanctioned by the state's refusal to modernize. For the New York divorce lawyer of this era, the primary skill wasn't cross-examination or oratory. It was logistics. They were essentially stage managers of a legal play. This era left a permanent mark on the New York legal psyche, instilling a culture of tactical aggression that persists today. Even in 2026, when we look at high-stakes matrimonial litigation, that heritage of investigative scrutiny remains a core component of the top-tier Manhattan firm's toolkit. Moving into the mid-20th century, we see the emergence of the financial discovery expert. As New York transformed into the global capital of finance, The assets being divided in a divorce became more complex than just a family home or a business. By the 1950s, lawyers were dealing with executive bonuses, stock options, and international holdings. This shifted the lawyer's role from a stage manager to a forensic accountant. Imagine a character named Michael, a high-earning executive at a top-tier firm in 1955. When his marriage hit the rocks, his lawyer didn't just look for a hotel room scandal. They looked for the hidden ledger. This period saw the first real use of subpoena power to track down assets hidden in shell companies or offshore accounts. The historical data from this transition period is fascinating. As the complexity of assets grew, so did the length of the trials. The New York divorce lawyer began to charge not just for their time, but for their specialized knowledge of the tax code. This is where we see the divergence between the general practitioner and the elite matrimonial specialist. The elite specialist understood that in a city like New York, the divorce wasn't just a social ending. It was a corporate dissolution. However, the 1966 reform we mentioned previously didn't just add new grounds for divorce. It fundamentally changed how property was viewed. Before 1980, New York was a title state. This meant that whoever's name was on the deed or the stock certificate owned the asset. If a wife stayed home to raise the children for 30 years while the husband built a multi-million-dollar real estate empire in his own name, the wife could walk away with nothing but a small amount of alimony. This was the era of the disposable spouse. The legal landscape shifted violently on July 19, 1980, with the passage of the Equitable Distribution Law. This was the single most important moment for the modern New York divorce lawyer. It moved the state from a title jurisdiction to an equitable distribution jurisdiction. Now, the court looked at marriage as an economic partnership. Any asset acquired during the marriage, regardless of whose name was on it, was considered marital property subject to fair distribution. Step by step, this changed the lawyer's strategy overnight. No longer were they just arguing about who was at fault, they were arguing about the value of a career. This led to some of the most controversial case studies in legal history, specifically regarding professional licenses. In the landmark 1985 case of O'Brien v. O'Brien, the New York Court of Appeals ruled that a medical license acquired during the marriage was a marital asset with a tangible dollar value. Imagine if you spent 10 years supporting your spouse through medical school, only for them to file for divorce once they became a surgeon. In New York, your lawyer could now argue that you were entitled to a percentage of the enhanced earning capacity that the degree provided. This created a gold rush for forensic evaluators. Lawyers now had to hire experts to calculate the present value of a future career. If a 35-year-old surgeon was expected to earn an extra $500,000 a year because of their degree, and they had 30 years of practice left, that license was worth millions in the eyes of the court. New York was one of the only states to take this extreme position, and it stayed that way for decades, creating a unique environment where a lawyer had to be part actuary, part economist. As we approach the current era of 2026, the complexity has only accelerated. The modern NYC lawyer is no longer just looking at medical licenses. They are valuing social media influence, digital real estate in the metaverse, and complex carry interest structures in private equity. Potential outcomes in these cases are no longer measured in thousands, but in the hundreds of millions. The lawyer's office in Midtown Manhattan now looks less like a law firm and more like a high-end consultancy, complete with in-house data scientists and private investigators who specialize in digital footprints rather than hotel room raids. But with this move toward a purely economic model, a new problem emerged. If the law removed the moral component of fault and replaced it with a mathematical formula for distribution, what happened to the human element? The New York divorce lawyer had to adapt again, becoming a master of psychological warfare and public relations. In a city where reputation is a currency as valuable as Bitcoin, the threat of a public filing can be a more powerful tool than any courtroom argument. This brings us to the era of the high-stakes privacy agreement and the rise of the mediation industrial complex. Why is it that in 2026, despite having no-fault divorce and clear equitable distribution laws, the average high-net-worth divorce in Manhattan still takes years to resolve and costs more than a suburban home in legal fees? The answer lies in the strategic use of delay and the weaponization of the long-tail asset. We are about to dive into the specific tactics used by the modern power attorney to freeze assets, utilize temporary restraining orders, and the one legal loophole that still allows New York lawyers to bring up fault to influence the financial split. If you think the end of the hotel room raid meant the end of the drama, You haven't seen how a modern lawyer can turn a Netflix password or a shared iCloud account into a multi-million-dollar settlement lever. But how did the most famous divorce in New York history, the 2019 split of a certain tech mogul, forever change how prenuptial agreements are drafted for the next generation of Manhattan power couples? That is where the real war begins. The year is 2026, and the landscape of Manhattan matrimonial law has moved far beyond the binary arguments of the 1980s. To understand how the 2019 split of a major tech titan reshaped the strategy of every elite New York divorce lawyer, we have to look at the death of the standard prenuptial agreement. Historically, a prenup was a defensive shield designed to protect premarital assets. But in the high-velocity economy of New York City, where a startup can go from a garage concept to a decacorn valuation in 36 months, the old defensive shield became obsolete. Lawyers realized that protecting what you have is easy. The real war is over the appreciation of what you built together. Imagine a character named Sarah, a venture capitalist living in a Tribeca loft in 2026. She is marrying James, a software architect. In 1995, a lawyer would have drafted a simple document listing their current bank accounts and properties. But in the post-2019 era, Sarah's lawyer is looking at historical trends and case studies regarding active versus passive appreciation. If Sarah's hedge fund grows by 400% during the marriage, is that growth a result of market forces, which are often considered separate property, or is it a result of her active management, which makes that growth a marital asset? This distinction is where the modern NYC divorce lawyer earns their reputation. Step by step, the attorney must now build a wall around the effort expended during the marriage, not just the asset itself. They use clauses that specifically define personal labor as a non-contributing factor to asset growth, a legal maneuver that is as delicate as it is expensive. This brings us to the evolution of the lifestyle clause and the weaponization of privacy. In the ultra-high net worth circles of New York, a divorce filing is a public record that can tank a stock price or trigger a morality clause in a corporate charter. Because of this, the modern lawyer has perfected the art of the pre-filing settlement. Case studies from the last 5 years show a significant trend. The most successful New York divorce lawyers are the ones whose clients never actually appear in the court system. They utilize private judges, retired Supreme Court justices hired at $1,000 an hour, to adjudicate the split behind closed doors. This ensures that the details of a family's private equity holdings, or their collection of rare digital artifacts, remain out of the tabloids. But what happens when the assets aren't just stocks and bonds? One of the most fascinating shifts in the last decade has been the inclusion of intellectual property and digital personas in equitable distribution. Imagine if James, our software architect, also has a massive following on a professional networking platform where he consults. That digital presence has a valuation. New York lawyers now routinely hire digital forensic firms to place a price tag on a personal brand. They analyze engagement rates, historical trends in ad revenue, and the potential outcomes of future sponsorship deals. If that brand was built while Sarah was paying the mortgage, Sarah's lawyer will argue that she is a silent partner in James's digital empire. This leads us to a deeper dive into the specific New York mechanism known as the automatic orders. The moment a summons with notice is served in a New York divorce, these orders kick in. They are designed to prevent either spouse from moving money, changing insurance policies, or hiding assets. However, in 2026, the complexity of moving money has bypassed traditional banking. A lawyer today must be proficient in tracking cold storage crypto wallets and decentralized finance protocols. We have seen case studies where a spouse attempted to wash marital funds through complex NFT trades, only to be caught by a lawyer who employed a blockchain investigator alongside their paralegals. This has turned the discovery process into a high-stakes digital scavenger hunt. The role of the lawyer has also expanded into the realm of the psychological strategist. In New York, where custody battles are often used as leverage for financial gain, a practice discouraged by the courts but frequently observed in high-conflict cases, the lawyer must navigate the forensic evaluation. This is a grueling process where a court-appointed psychologist interviews the family to determine the best interests of the child. A savvy attorney doesn't just represent their client. They prepare them for these evaluations as if they were prepping for a congressional hearing. They provide step-by-step guidance on how to document parental involvement, how to communicate via court-monitored apps, and how to avoid the parental alienation trap that can result in a loss of custody and, by extension, a loss of the family home. The family home in New York City is itself a unique legal beast. Unlike a suburban house in Ohio, A Manhattan co-op board has more power than almost any other entity in a divorce. Even if a judge orders that a husband must transfer the apartment to his wife, the co-op board can reject her as a shareholder. This creates a legal stalemate that only a New York specialist knows how to break. They might draft a license to occupy agreement or negotiate a buyout that includes the board's approval. Historical trends show that these real estate complications can extend a divorce by 18 to 24 months, during which time the legal fees can spiral into the high six figures. Furthermore, we must look at the Manel or maintenance formulas. In 2016, New York overhauled its alimony laws to create a more predictable formula for spousal support. However, for those earning over a certain threshold, currently capped at around $228,000 of the payer's income for the formulaic portion, the judge has wide discretion. This is where the masterclass level of lawyering happens. An attorney must argue why their client deserves a lifestyle that exceeds the basic formula. They use case studies of past luxury expenditures, the private jets, the summer rentals in the Hamptons, the elite prep school tuitions, to argue that the standard of living established during the marriage must be maintained. But there is a darker side to this evolution. As the financial stakes have risen, so has the use of the scorched earth policy. This involves filing dozens of motions to deplete the other side's legal fund. Since New York law allows the less moneyed spouse to request that the moneyed spouse pay their legal fees, this creates a bizarre incentive structure. The less moneyed spouse's lawyer might litigate aggressively, knowing the bill will eventually be sent to the opposing side. Conversely, the moneyed spouse might hide assets to appear less wealthy. It is a game of financial chicken that has become a hallmark of the New York City courtrooms. The complexity of these cases has given rise to the boutique matrimonial firms that don't do anything but high net worth divorce. They are the Navy SEALs of the legal world, operating with small, highly specialized teams. They understand that a divorce in New York isn't just about the law. It's about the exhaustion of the opponent. As we look toward the next phase of this analysis, we have to ask, what happens when the assets are not just hidden but are conceptually intangible? We've discussed degrees and brands, but what about the enhanced earning capacity of a celebrity or a CEO whose value is tied to their public image? And more importantly, how did the introduction of no-fault divorce in 2010 actually lead to a secret resurgence of fault in the form of egregious cruelty? The legal loophole that allows a lawyer to bring up a spouse's worst behavior to affect the financial split is the most guarded secret in the Manhattan legal circuit. If you think no fault meant the end of the dirty divorce, you are about to see how the definition of egregious has been stretched to include everything from financial domestic abuse to international kidnapping. The next part of our deep dive explores the high-stakes world of the trial of the century that no one was allowed to watch, and the specific tactic that can still leave a billionaire with nothing. To truly understand the specific tactic that can leave even a billionaire with nothing, we have to look at the legal doctrine of egregious cruelty and how it functions as the hidden trapdoor in New York's no-fault system. While the 2010 legislation was intended to remove the need for mudslinging, it left open a narrow, high-stakes window in Section 236 of the Domestic Relations Law. This window allows a judge to consider the fault of a party if that behavior is so shocking that it offends the conscience of the court. In the hands of a top-tier New York divorce lawyer in 2026, this is the nuclear option. Imagine a character named Robert, a hedge fund titan with an estimated net worth of $1.2 billion. Under standard equitable distribution, his wife, Elena, might expect a significant percentage of the assets accumulated during their 20-year marriage. However, if Robert's lawyer can provide evidence of egregious behavior, not just standard infidelity, but something that crosses a moral and legal event horizon, the entire financial calculation shifts. Historically, New York courts have defined egregious conduct very narrowly, usually involving physical violence that rises to the level of attempted murder or extreme financial domestic abuse. But as we move deeper into 2026, the definition is being tested by digital age case studies involving what lawyers call cognitive or reputational assassination. If Robert were to use his vast resources to systematically destroy Elena's ability to function in society, perhaps by hacking her communications to leak sensitive health data or using deepfake technology to ruin her professional reputation, a New York judge might invoke the egregious conduct rule. In such a scenario, the potential outcome is not just a slightly smaller slice of the pie. The court has the power to strip the offending party of their entire share of the marital estate. This is the trial of the century that happens behind closed doors, because the evidence is often too sensitive for public consumption. The lawyer's role here shifts from accountant to prosecutor, building a dossier of behavior that is so reprehensible, it overrides the 50-50 starting point of equitable distribution. This leads us to the concept of wasteful dissipation of assets, a much more common but equally lethal tool in the Manhattan divorce lawyer's arsenal. Historical trends show that when a marriage begins to fail, one spouse often begins to bleed the marital accounts. In 2026, this doesn't just look like buying a luxury car for a paramour. It looks like deliberate, high-risk investments designed to fail, or moving funds into speculative digital assets that are then conveniently lost in a forgotten hardware wallet. Step by step, a lawyer must prove that these financial moves were not just bad luck, but a bad faith attempt to reduce the marital pot. They hire forensic auditors who specialize in tracing the velocity of money. If Elena can show that Robert moved $50 million into a shell company that then purchased overpriced artwork from a gallery owned by a close associate, her lawyer will claim a credit for wasteful dissipation. The court then treats that $50 million as if it still exists in Robert's pocket when it comes time to divide the remaining assets. This effectively penalizes the dissipating spouse dollar for dollar, potentially leaving them with the debt and the other spouse with the tangible cash. But how do you prove intent in a city where $50 million movements are considered routine business? This is where the New York lawyer's skill in the deposition room becomes legendary. In 2026, these depositions are often conducted with AI-assisted sentiment analysis, where every micro-expression and hesitation is logged to find the lie. The goal is to catch the spouse in a contradiction regarding their business judgment versus their marital obligations. Another critical layer in this masterclass is the valuation of the non-moneyed spouse's contribution as a homemaker and parent. In New York, the law explicitly states that the court must consider the contribution made by the party who stayed at home to the career of the party who earned the money. However, the calculation of this value is a battlefield. In the past, lawyers might have argued for the cost of a live-in nanny and a chef. In the modern era, the argument is much more sophisticated. A lawyer representing Elena would argue that her role was that of a chief operating officer of the family. She managed the social calendar that led to Robert's biggest investors. She curated the reputation that allowed him to command a premium in the market. She handled the logistics of multiple households, so he could focus 100% of his cognitive load on the markets. Case studies from recent years show that New York judges are increasingly receptive to this holistic view of marriage as a joint venture partnership. The lawyer must provide a step-by-step breakdown of how the non-moneyed spouse's labor directly correlated with the moneyed spouse's rise in income. This isn't about the cost of labor. It's about the value of the support. If Robert's income jumped from $5 million to $50 million during a period when Elena took over all domestic and social responsibilities, her lawyer will argue that she is entitled to a significant portion of that $45 million delta. However, the moneyed spouse's lawyer has a countermove, the argument of the extraordinary talent. They will argue that Robert's success was not due to the support at home, but due to his unique, innate genius that would have manifested regardless of his marital status. This sets up a clash of expert witnesses, sociologists versus economists, all arguing over the source of a human being's success. It is a highbrow, incredibly expensive debate that can determine the fate of hundreds of millions of dollars. As we look at these high-stakes maneuvers, we must also consider the role of the temporary maintenance and counsel fee awards. In New York, there is a legal presumption that the moneyed spouse should pay the legal fees of the non-moneyed spouse to ensure a level playing field. This is unique compared to many other states. It means that Elena can hire the most expensive, most aggressive lawyer in the city, and Robert has to write the check for his own opposition. This creates a fascinating dynamic where the non-moneyed spouse's lawyer has an almost unlimited budget to investigate the moneyed spouse. But there is a catch. If the court later finds that the non-moneyed spouse acted in bad faith or hid their own assets, they may have to pay those fees back or have them deducted from their final settlement. This makes every motion a calculated risk. The lawyer must balance the need for aggressive discovery with the potential for a financial backlash at the end of the case. The complexity of these strategies is why the New York City divorce bar is considered the most elite in the country. They are playing a game where the rules are written in decades-old case law, but the pieces are 21st-century financial instruments. We've seen how fault can return as egregious cruelty, and how a career can be valued like a corporation. But there is one area that still baffles even the most seasoned attorneys: the division of international assets in a world where geopolitical boundaries are shifting. What happens when a Manhattan couple owns a vineyard in a country currently under international sanctions, or a penthouse in a city that no longer recognizes U.S. court orders? And how does the New York lawyer handle the ultimate complication, the frozen embryo? As we move into Part 5, we will explore the frontier of biolegal warfare and the international jurisdictional battles that make a standard Manhattan divorce look like a simple math problem. The question of who owns the future of a family's genetic material is the new frontline, and the precedents being set in New York right now will govern the rest of the world for the next century. The battle over genetic material represents the most profound shift in the history of New York matrimonial law, moving the divorce lawyer away from the ledger and into the laboratory. To understand the stakes in 2026, we must look at the step-by-step evolution of how the state treats cryopreserved embryos. Historically, these were often viewed through the lens of contract law. If a couple signed a form at a fertility clinic stating that the embryo should be destroyed in the event of a divorce, the court usually enforced that contract. However, as reproductive technology has advanced, New York case studies have become increasingly complex, particularly when those embryos represent a spouse's last biological chance to have a child. Imagine a character named Catherine, a 42-year-old executive in Manhattan. During her marriage to David, they underwent several rounds of IVF, resulting in 3 frozen embryos. As they enter divorce proceedings in 2026, Catherine wants to use the embryos to become a mother, while David, citing his right not to be forced into procreation, wants them destroyed. In the past, the right not to procreate almost always won. But a new wave of New York legal strategy is challenging this. Catherine's lawyer isn't just arguing about a contract, they are arguing about the concept of promissory estoppel. They will present a detailed timeline showing how Catherine relied on David's participation in the IVF process, potentially sacrificing other reproductive opportunities during the marriage. The potential outcomes in these cases are no longer predictable. The modern New York divorce lawyer must now navigate the intersection of the Domestic Relations Law and the 2019 Child Parent Security Act. This is a biolegal minefield where the attorney has to hire medical ethicists and embryologists as expert witnesses. They are no longer just arguing about who gets the summer house, they are arguing about the very existence of future human life. This has created a specialized niche within the Manhattan bar, the reproductive matrimonial specialist. These attorneys draft specific genetic prenups that go far beyond what any lawyer in the 1990s could have imagined, detailing every possible scenario from simultaneous death to the religious upbringing of a child not yet born. But as the battle for the future of the family intensifies at home, the New York lawyer is also facing an unprecedented challenge abroad. New York has always been a global city, but in 2026, the internationalization of assets has reached a breaking point. We are seeing a surge in jurisdictional arbitrage, where a spouse will flee to a foreign country with a completely different legal system to file for divorce before their partner can serve them in Manhattan. This is known as the race to the courthouse, and in New York, the stakes of winning that race can be worth hundreds of millions of dollars. Consider a case study involving a high-ranking official at an international bank with homes in London, Paris, and the Upper East Side. If the husband files in London, where the laws regarding the sharing principle have historically been more favorable to the breadwinner in certain high-wealth scenarios, the wife could lose out on the equitable distribution she would receive under New York law. The New York lawyer's first move in 2026 is often an anti-suit injunction. This is a sophisticated legal maneuver where a New York judge orders a spouse to stop proceedings in a foreign court. To pull this off, the lawyer must prove that New York is the center of gravity for the marriage, tracking everything from where the children go to school to where the family's most frequent grocery deliveries occur. Step by step, the lawyer builds a case for New York jurisdiction by analyzing digital footprints. They will subpoena records from ride-sharing apps, private jet logs, and even smart home data to show that the couple spent 183 days or more in the Empire State. In 2026, the 183-day rule is the holy grail of jurisdictional battles. If you can prove your client is a New York resident, you unlock the power of New York's aggressive discovery laws, which allow lawyers to peer into every corner of a spouse's financial life, including assets held in offshore trusts. This brings us to the piercing of the trust. For decades, the wealthy used irrevocable trusts to shield assets from divorce. The historical trend was that if the money was in a trust, it was out of reach. But the New York divorce lawyer of 2026 has developed a toolkit to crack these structures open. They look for what is called de facto control. If the husband is the beneficiary of a trust but also has the power to fire the trustee or directs how the money is invested, a New York lawyer will argue that the trust is a sham or an alter ego. They will use forensic accountants to show that the trust functioned as a personal piggy bank for the marriage, paying for the family's vacations and household staff. If successful, the court can reach through the trust and count those assets as marital property. The complexity increases when those trusts are located in asset protection jurisdictions, like the Cook Islands or Nevis. Here, the New York lawyer must play a game of legal chess. While they might not be able to force a foreign trustee to hand over the money, they can convince a New York judge to award the non-moneyed spouse a larger share of the assets that are within the court's reach, like Manhattan real estate, to offset the value of the hidden offshore funds. This is known as an offset award, and it is the primary way New York lawyers bypass international banking secrecy. As we examine these high-level maneuvers, we must also acknowledge the rising role of the guardian ad litem for property. In exceptionally messy divorces involving complex business interests, the court may appoint a neutral third party to manage a company or an asset while the divorce is pending. For a New York lawyer, this is a moment of extreme risk. They must ensure that the person appointed doesn't tank the value of the business while trying to be neutral. This requires the lawyer to have a deep understanding of corporate governance, further blurring the line between a family lawyer and a corporate litigator. We are seeing a trend where the top divorce firms in NYC are no longer just hiring from law schools. They are poaching talent from the M&A departments of big law firms. The reason is simple. A 2026 Manhattan divorce is essentially a forced merger and acquisition where the parties hate each other. The lawyer must manage the valuation of carried interest in private equity firms, the clawback provisions of executive compensation packages, and the tax implications of transferring massive blocks of stock, all while dealing with the emotional volatility of a failing marriage. But even with all this financial and biological warfare, there is one factor that can still bring a billion-dollar case to its knees: the social media discovery order. In 2026, we have seen case studies where a spouse's entire financial defense was dismantled because of a single post by a third party. If a husband claims he has no money, but his girlfriend posts a photo of them on a private yacht in the Maldives, the New York lawyer will use that metadata to sink his credibility. This leads us to a startling realization. While the law has become more no-fault and more mathematical, the evidence has become more intrusive. We have moved from the hotel room raid of the 1920s to the cloud storage raid of 2026. The New York divorce lawyer is now a digital ghost, haunting the servers of their client's ex-spouse. But what happens when the digital evidence is encrypted beyond the reach of even the most powerful subpoena? And how is the AI-driven prenup of the future already predicting the end of marriages before the wedding cake is even cut? The next part of our deep dive explores the rise of predictive matrimonial analytics and the secret world of divorce funding, a multi-billion-dollar industry where Wall Street investors bet on the outcome of New York's biggest breakups. You are about to see how your divorce could become a tradable asset on a private exchange. The emergence of divorce funding, also known as matrimonial litigation financing, has fundamentally altered the power dynamics of the New York City legal landscape in 2026. Historically, the moneyed spouse held all the cards because they could outspend their partner until a lowball settlement was the only option for survival. But today, the New York divorce lawyer is often working alongside private equity-backed firms that view a high-stakes divorce as a high-yield investment opportunity. This is not a loan in the traditional sense. It is non-recourse funding. This means the investor provides the capital for legal fees, forensic accountants, and lifestyle maintenance in exchange for a percentage of the final settlement. If there is no settlement, the investor loses their money. Imagine a character named Elizabeth, whose husband is a founding partner of a major Manhattan private equity firm. Elizabeth has no personal income, and her husband has systematically cut off her access to their joint accounts, a tactic known as financial strangulation. In 1980, Elizabeth would have been at the mercy of the court to grant her a slow-moving counsel fee award. In 2026, her lawyer makes a phone call to a litigation funder. The funder conducts a deep-dive analysis of the marital estate, assessing the historical trends of similar asset divisions in the New York Supreme Court. They see a high-probability case with potential outcomes in the tens of millions. Within 48 hours, Elizabeth has a multi-million-dollar war chest. This shift has created what we call predictive matrimonial analytics. These funding firms use proprietary algorithms to scan thousands of past New York divorce filings. They analyze specific judges, the win-loss records of opposing counsel, and the typical valuation discounts applied to Manhattan real estate. They aren't just betting on the law, they are betting on the data. For the New York divorce lawyer, this means their client now has the staying power to reject unfair deals and take the case to a full trial if necessary. It has leveled the playing field, but it has also commodified the end of a marriage. The investor now has a seat at the table, and while they cannot ethically dictate legal strategy, their financial presence influences every move. Step by step, this funding process involves a rigorous due diligence phase that rivals a corporate merger. The lawyers must present the funder with a comprehensive case theory, a detailed list of known assets, and a roadmap of the discovery process. They use case studies of recent New York Appellate Division rulings to justify their valuation of intangible assets like carried interest and intellectual property. If the funder sees a risk, perhaps a strong prenuptial agreement that might hold up, they may pass. But if the prenup has vulnerabilities, such as a lack of full financial disclosure at the time of signing, the funder will double down. This leads us to the contemporary war over the prenuptial agreement in 2026. In New York, a prenup is presumed to be valid unless the challenging party can prove it was the product of fraud, duress, or overreaching. However, the modern NYC lawyer has found a new angle: unconscionability at the time of enforcement. This is a subtle but powerful distinction. A lawyer might argue that while the agreement was fair when it was signed in 2010, the circumstances of 2026 make its enforcement a violation of public policy. Take the case study of a spouse who gave up a promising career in biotechnology to support the other's rise in the fintech sector. If the prenup provides for zero maintenance and a small lump sum, but the moneyed spouse is now earning $50 million a year, a New York lawyer will argue that the disparity is so great it shocks the conscience. They will look for any procedural flaw. Was the agreement signed too close to the wedding date? Was there a one-lawyer trap where the non-moneyed spouse was encouraged to use a firm recommended by the other side? These are the cracks that a 500-page forensic report can turn into a canyon. The technology used in these investigations has moved into the realm of the truly futuristic. In 2026, we are seeing the use of AI-driven document review that can scan 30 years of tax returns, bank statements, and Venmo histories in seconds to find a single anomalous transaction. If a spouse has been drip-feeding money to a secret account, the software flags the pattern. This has made the lifestyle analysis a terrifyingly accurate tool. The lawyer no longer asks what you spend. They tell you what you spent based on your digital footprint. They can compare the reported income to the observed expenses, the five-star hotels, the private school tuitions, the art auctions, and present a judge with a mathematical proof of hidden income. But there is a counter-trend emerging in the New York legal circuit: the rise of the luxury mediation retreat. As the cost and intrusiveness of litigation reach these heights, the ultra-wealthy are opting for private, high-end mediation. This isn't sitting in a sterile office. This is a 3-day intensive in a secure location in the Hudson Valley or the Hamptons. The divorce lawyer here acts more like a diplomat. The goal is a global settlement that covers everything from the division of the NFT collection to the future board seats of the family foundation. These mediation sessions use a technique called the neutral evaluator model. The parties hire a retired judge to hear both sides and give a non-binding opinion on how a court would likely rule. For a New York lawyer, this is a masterclass in risk management. They use the evaluator's feedback to convince their client to settle, avoiding the potential outcomes of a public trial where a judge might make an unpredictable, equitable decision that satisfies no one. Yet, even in mediation, the specter of the hidden asset looms large. In 2026, the hottest topic in Manhattan divorce is the valuation of the automated business. We are seeing cases where a spouse has built an AI-driven trading bot or an automated e-commerce empire that requires zero daily labor. Is this business active or passive property? If the bot was coded during the marriage but continues to generate millions in profit after the separation without any further work, how is that income treated? The New York lawyer must argue whether this is more like a pension, marital, or more like a future salary, separate. This brings us to a critical intersection of law and technology. The modern New York lawyer is now dealing with smart contracts in divorce settlements. Imagine a settlement where the alimony is paid automatically via a blockchain protocol, with the amount adjusting in real time based on the consumer price index or the performance of the S&P 500. This eliminates the need for contempt of court filings for non-payment, but it introduces a new risk. What happens if the code has a bug or the oracle feeding the data is compromised? As we move toward the final sections of our analysis, we have to address the psychological toll that this high-stakes legal warfare takes on the practitioners themselves. The New York divorce lawyer is operating in a pressure cooker where a single missed deadline or a failed subpoena can result in a multi-million-dollar malpractice suit. This has led to the institutionalization of the divorce firm, where teams of lawyers, data scientists, and crisis PR managers work in shifts. The battle for the Upper East Side is no longer just about who gets the apartment. It's about who controls the narrative in a world where information is the ultimate weapon. But what happens when the information being used is not just digital but biological? And how is the postnuptial agreement becoming the preferred tool for couples who want to stay married but need to reindex their financial relationship in a volatile 2026 economy? The next part of our deep dive focuses on the Save the Marriage contract, the secret legal document that is keeping Manhattan's elite together, and the one clause that can make a divorce impossible before it even begins. You are about to see how the New York lawyer is now being paid to prevent the very thing they were once hired to create. In the high-stakes environment of 2026 Manhattan, the postnuptial agreement has transformed from a sign of a failing marriage into a strategic tool for marital preservation. Historically, these documents were viewed with skepticism by the courts, often seen as a way for a dominant spouse to coerce a better deal once the wedding vows were already exchanged. However, current historical trends in New York law show that a properly executed postnup can actually stabilize a relationship by removing the financial ambiguity that fuels domestic conflict. This is the era of the reconciliation agreement, a specific type of contract where a New York divorce lawyer is hired not to end the union, but to draft the terms upon which the couple agrees to stay together. Imagine a character named Christopher, a tech founder whose company is approaching an initial public offering in late 2026. His wife, Amanda, has expressed concerns about the lack of transparency regarding their future wealth. In a traditional setting, this friction might lead to a divorce filing to lock in discovery rights. Instead, their respective lawyers draft a postnuptial agreement that reindexes their assets. This document might include a sunset clause on their original prenuptial agreement, or establish a new formula for equitable distribution that accounts for the massive spike in the company's valuation. By defining the potential outcomes of a future split while the relationship is still functional, the lawyers effectively neutralize the financial incentive to file for divorce prematurely. A key component of these 2026 agreements is the lifestyle and conduct provision, though these must be handled with extreme care under New York law. While you cannot legally contract away child support or create an agreement that is unconscionable, you can create financial consequences for specific behaviors that the couple identifies as deal breakers. Step by step, the lawyer must ensure these clauses do not violate public policy. For instance, an agreement cannot fine a spouse for filing for divorce, as New York maintains that the right to seek a dissolution of marriage is a fundamental legal entitlement. However, a lawyer can structure the distribution of a specific investment account so that it shifts in favor of the non-offending spouse in the event of documented financial infidelity, such as the secret gambling of marital funds. This brings us to the most controversial tool in the 2026 Manhattan legal arsenal, the anti-litigation clause. While a lawyer cannot make a divorce impossible, they can make it prohibitively expensive and strategically difficult through a series of interlocking procedural hurdles. These agreements often require a mandatory one-year cooling-off period involving high-level mediation and collaborative law protocols before a summons can even be served. The goal is to prevent the impulse filing that often happens in the heat of an argument, which in a city like New York, can trigger a chain reaction of automatic orders and frozen assets that are nearly impossible to reverse. Case studies from the past 3 years show that these Save the Marriage contracts are increasingly popular among New York's ultra-high net worth families who are managing multi-generational wealth. The lawyers involved are often working in tandem with family office advisors and psychologists. They are creating a legal framework for a partnership that is as much a corporate entity as it is a romantic one. In these scenarios, the divorce lawyer acts as a risk management consultant. They analyze the historical trends of the couple's spending and asset acquisition to create a fairness buffer. If the marriage lasts another 10 years, the payout for the non-moneyed spouse increases by a specific percentage, essentially creating a loyalty bonus that is legally enforceable as part of the equitable distribution. However, the complexity of 2026 law means that even these sophisticated agreements have vulnerabilities. The concept of overreaching remains the primary weapon for any lawyer looking to break a postnup. If Christopher's lawyer presented the document to Amanda without giving her sufficient time to consult her own independent counsel, or if the financial disclosure was even slightly incomplete, the entire agreement can be set aside. In New York, the fiduciary duty between spouses is higher than between two business partners. This means that a husband and wife must act with the utmost good faith toward each other. A lawyer who fails to document the arm's-length nature of the negotiation is essentially handing the opposition a map to the agreement's destruction. Furthermore, we are seeing the rise of the social media and reputation clause within these postnups. In an era where a single viral post can destroy a family's brand or a CEO's standing, lawyers are drafting liquidated damages clauses for disparagement. If a spouse goes on a public tirade that results in a measurable dip in a company's stock or the loss of a professional license, the agreement can stipulate an immediate financial offset. This is particularly relevant in New York, where the intersection of the social elite and the global media is a constant factor in legal strategy. But what happens when the very technology designed to protect the marriage becomes the evidence that ends it? In 2026, we are witnessing the emergence of the smart home deposition. Many Manhattan townhouses are now equipped with integrated AI systems that log everything from movement patterns to the emotional tone of conversations for the purpose of wellness tracking. In a high-conflict divorce, a New York lawyer will move to subpoena these logs. If a spouse claims they were a supportive partner while the AI logs show a consistent pattern of verbal abuse or late-night absences, the Save the Marriage contract may actually provide the data that ensures the marriage's final, expensive dissolution. The role of the lawyer in this phase is to manage the exit architecture. Even when they are hired to prevent a divorce, they must build the document so that if a divorce does happen, it is pre-settled. This means the agreement contains a step-by-step roadmap for the division of every asset, from the art collection in the Hamptons to the fractional ownership of a private jet. By doing this, the lawyer is essentially trying to put their future self out of business. If the agreement is perfect, there will be no litigation, no discovery, and no trial. Yet, there is a paradoxical outcome to this trend. As agreements become more perfect and automated, the fight moves into the realm of the voidable act. If a spouse can prove they were under extreme emotional distress, verified by biometric data from a wearable device, when they sign the postnup, they might be able to claim diminished capacity. This has led to the bizarre practice of lawyers requiring a psychiatric evaluation of both parties on the day a high-stakes agreement is signed, just to bulletproof the document against future claims of duress. As we look toward the final stages of this analysis, we must ask, if the lawyer is now a data scientist, a psychologist, and a corporate strategist, what is left of the original courtroom advocate? The evolution of the New York divorce lawyer has reached a point where the most successful practitioners are those who never have to speak in front of a judge. But there is one final, emerging frontier that is threatening to upend the entire industry. A new breed of decentralized autonomous divorces is appearing on the horizon, systems that use blockchain oracles to bypass the New York Supreme Court entirely. How is the New York bar reacting to this threat to their centuries-old monopoly? And what is the global finality clause that is currently being tested in the highest courts of the state, which could change the definition of divorced for every American citizen? The endgame of the Manhattan divorce industry is about to be revealed. The concept of decentralized autonomous divorces, or DADs, represents the ultimate disruption to the traditional New York legal monopoly. In 2026, we are seeing the first real-world applications of smart contracts designed to automate the dissolution of a marriage without the direct intervention of a human judge or a $1,000 an hour attorney. This is not science fiction. It is the logical conclusion of the move toward algorithmic fairness. A DAD is essentially a pre-programmed legal protocol hosted on a blockchain. When certain conditions are met, such as a specific period of separation verified by geolocation data or a mutual digital signature, the protocol automatically executes the transfer of assets, updates property titles, and triggers maintenance payments. Imagine a character named Jennifer, a digital nomad and software developer living in a Brooklyn micro-apartment. She and her spouse entered into a blockchain-based marriage contract in 2022. Every asset they acquired was tokenized: their car, their savings, and even their fractional ownership in a Catskills retreat. When they decided to part ways in early 2026, there was no year-long discovery phase. The smart contract, which had been tracking their financial contributions in real time, executed a mathematical split based on a pre-agreed formula. The potential outcomes were determined at the moment of the wedding, not the moment of the split. For Jennifer, the divorce was finalized in the time it took for a block to be added to the chain, bypassing the backlog of the New York Supreme Court entirely. This technological shift has forced the New York City divorce lawyer to undergo a radical identity crisis. Historically, the lawyer was the gatekeeper to the court. Now they are becoming the architects of the code. The elite firms in Manhattan are now hiring legal engineers to audit these smart contracts. They are looking for bugs, edge cases, and jurisdictional vulnerabilities. The case studies of 2026 are no longer about secret mistresses. They are about Oracle failures. If the smart contract was supposed to adjust alimony based on the price of Ethereum, and the price Oracle was manipulated, who is liable? This is the new frontier of malpractice and litigation. Furthermore, the New York Bar is currently lobbying for the Global Finality Clause. This is a proposed legal standard that would allow New York courts to recognize these decentralized divorces as legally binding, provided they meet certain due process requirements. If passed, this would change the definition of divorce for every American citizen because New York, as a global financial hub, often sets the pace for international recognition of legal status. If a New York court says a blockchain automated split is valid, banks and governments worldwide are likely to follow suit. This would essentially create a fast lane for divorce that leaves traditional litigation for only the most complex, high-conflict cases involving non-tokenized assets or custody disputes. Step by step, the implementation of these automated systems follows a strict logic. First, the parties must opt in via a comprehensive digital agreement that waives their right to a traditional trial for financial matters. Second, all marital assets must be brought on-chain or linked to a digital twin that the smart contract can control. Third, a set of dispute resolution nodes, often retired judges acting as digital arbitrators, are programmed into the contract to handle any anomalies. This system provides a level of transparency that was previously impossible. In a traditional divorce, one spouse might suspect the other is hiding cash. In a DAD, if the money isn't on the ledger, it doesn't exist for the purpose of the automation, which places a massive premium on upfront transparency. But what about the human element that technology cannot quantify? This is where the New York lawyer finds their remaining stronghold. While a machine can divide a bank account, it cannot determine the best interests of a child or assess the psychological impact of a midlife career change. In 2026, we are seeing the rise of the hybrid divorce. The financial assets are handled by automated protocols, while the human issues, custody, visitation, and emotional mediation are handled by a new breed of boutique lawyers who specialize in human-centric advocacy. These lawyers are trained in restorative justice and therapeutic jurisprudence, moving away from the adversarial win-at-all-costs mentality of the 1990s. Historical trends show that whenever the law becomes too automated, a counter-reaction occurs where the exceptions become the most valuable part of the practice. We are seeing case studies where spouses attempt to hack their own divorces by providing biased data to the AI evaluators. If a husband knows the AI prioritizes stability in custody cases, he might use smart home data to create a curated, artificial image of a perfect routine. The lawyer's job in 2026 is to peer behind the data curtain and prove that the digital representation of the marriage is a fraud. This leads us to the endgame of the Manhattan divorce industry: the consolidation of the full-service lifecycle firm. The top-tier firms are no longer just waiting for you to get a divorce. They are selling marital maintenance subscriptions. For a monthly fee, a firm provides ongoing legal, financial, and psychological consulting to keep the marriage's legal health in check. They update postnups annually, manage tax-efficient asset transfers between spouses, and provide early warning mediation when behavioral patterns shift. They have realized that the real money isn't in the one-time explosion of a divorce, but in the lifetime management of the high-net-worth partnership. However, a significant legal battle is brewing over the right to a human judge. Some advocacy groups in New York are arguing that delegating the power of the state to a blockchain or an AI algorithm is unconstitutional. They argue that the conscience of the court, that intangible ability of a human judge to see a unique situation and deviate from the formula, is a prerequisite for justice. The New York lawyer is at the center of this constitutional crisis, arguing both for the efficiency of the new systems and the necessity of the old ones. As we look at the data from early 2026, the potential outcomes for the profession are split. In one scenario, the middle-market divorce lawyer disappears, replaced by apps and automated protocols. In the other, the elite lawyer becomes even more powerful, acting as the high priest of the systems that govern the wealth of the global 1%. The gap between the automated divorce and the bespoke litigation is widening, creating a two-tiered justice system in New York City that mirrors the city's own wealth inequality. But there is one final piece of the puzzle that no one saw coming. It involves the intersection of New York matrimonial law and the burgeoning industry of longevity science. What happens to a till death do us part contract in a world where death is being pushed back by decades, or where biological age can be reversed? If a 70-year-old spouse undergoes a rejuvenation treatment and effectively becomes 30 again, does the original marriage contract, drafted under the assumption of a shared aging process, still hold? The New York lawyer is currently drafting the first longevity clauses to address this exact scenario. We are about to enter a world where the length of a marriage is no longer measured in years, but in biological phases. The final two parts of our deep dive will reveal how the quest for eternal life is creating the most complex legal documents in human history, and how the eternal prenup is the only thing standing between a rejuvenated billionaire and total financial ruin. The next part focuses on the biofinancial reset, the moment the law has to decide if you are still the same person you were when you said I do. The concept of the biofinancial reset is no longer a hypothetical debate in the faculty lounges of NYU Law. In 2026, it is a living, breathing crisis in the courtrooms of 60 Center Street. As longevity science advances from the fringes of Silicon Valley to the elite medical suites of the Upper East Side, the New York divorce lawyer is facing a fundamental challenge to the concept of the marital contract. If a marriage is a contract between two specific people, what happens to that contract when one of those people undergoes a biological transformation so radical that their cognitive age, physical health, and even personality profile shift back 3 decades? This is the core of the 2026 legal frontier: the identity persistence defense in matrimonial law. Imagine a character named David, a 75-year-old real estate mogul who has been married to his wife, Barbara, for 50 years. In 2024, David began a series of experimental epigenetic reprogramming treatments. By 2026, David's biological markers indicate he has the physical vitality and cognitive plasticity of a 40-year-old. He decides he wants a second life, which does not include his 50-year marriage. Barbara's lawyer is now forced to argue against a biological reality. If David is effectively a new man, does the equitable distribution of assets acquired over 5 decades still apply to this rejuvenated version of him? Historical trends suggest that New York courts prioritize the partnership theory of marriage, but David's lawyers are testing a new case study: the frustration of purpose. They argue that the marriage was predicated on a shared journey of aging and mutual decline, and since that journey has been biologically disrupted, the contract itself is frustrated. This has led to the development of the longevity clause in modern New York prenuptial and postnuptial agreements. Step by step, these clauses define marriage not just in terms of years, but in terms of biological epochs. A 2026 agreement drafted by a top-tier Manhattan firm might state that in the event of a successful age reversal treatment exceeding a 10-year biological shift, a mandatory reevaluation of the marital estate is triggered. This prevents the rejuvenated spouse from exiting the marriage with half the assets while possessing a significantly longer projected lifespan to earn more, leaving the non-rejuvenated spouse with a fixed asset pool and a shorter life expectancy. The potential outcomes of these cases are reshaping the very definition of fairness. Lawyers are now hiring biostatisticians to project life-adjusted valuations. If Barbara is expected to live another 15 years, but David is now projected to live another 50, the court must decide if equitable means a 50-50 split or if it requires a longevity adjustment to ensure Barbara is not left impoverished in her final years while David enjoys a multi-decade windfall. This is the biofinancial reset in action. It is a mathematical and moral calculation that the New York Bar is currently trying to standardize before the floodgates of longevity litigation truly open. Furthermore, we are seeing the rise of cognitive continuity audits. In New York, for a contract to be valid, the parties must have the capacity to enter into it. But what happens if the rejuvenation process alters the personality to the point that the individual no longer identifies with the choices of their older self? In 2026, lawyers are utilizing neuroforensics to map the personality traits of their clients before and after treatments. Case studies are emerging where a spouse claims that the biological reset was so profound it constituted an involuntary change in character, making the enforcement of old marital promises a form of identity theft. This leads to a secondary, equally complex issue: the valuation of the rejuvenation asset. In New York, as we have established, A professional license or a career's enhanced earning capacity can be a marital asset. In 2026, a lawyer will argue that the millions of dollars spent on David's biological rejuvenation during the marriage was a marital investment. If the marital estate paid for David to get younger, then Barbara is entitled to a percentage of the projected earnings David will generate in his extra 30 years of career productivity. The lawyer must provide a step-by-step valuation of this extra life, as if it were a patent or a long-term corporate bond. However, the defense against this is the bodily autonomy shield. David's lawyers will counter that a person's biological age is an inherent part of their personhood, not a piece of property that can be divided. They argue that you cannot put a price tag on a heartbeat or a renewed set of stem cells. This creates a collision between two of New York's most sacred legal pillars, the partnership theory of marriage and the inalienability of the self. The New York divorce lawyer is at the epicenter of this collision, drafting arguments that will eventually reach the Court of Appeals, and likely the Supreme Court of the United States. As we look at the data from the first half of 2026, we see a 15% increase in biological-related filings in the Manhattan matrimonial parts. These are often accompanied by temporary bioinjunctions, where a spouse tries to prevent the other from undergoing rejuvenation treatments until a financial settlement is reached, arguing that the treatment itself is a dissipation of marital assets, or a move to fundamentally alter the legal standing of the party. It is a world where a lawyer can move the court to freeze your own biological clock to protect a bank account. The complexity of these biodivorces has given rise to the matrimonial bioethicist, a new consultant role within the NYC law firm. These experts help lawyers navigate the optics of these cases. In a city as sensitive to social standing as New York, appearing to abandon an aging spouse after getting younger is a PR nightmare that can affect a CEO's key man insurance or a socialite's board positions. The lawyer must manage the reputational risk of the bio reset, often advising clients to settle for significantly higher amounts just to avoid the gilded age level of public shaming that follows such a move. But there is a final, even more disturbing trend. We are seeing the emergence of the intergenerational prenup. As life expectancy increases and wealth stays concentrated in the hands of the rejuvenated elderly, the inheritance that once fueled the New York economy is being pushed back indefinitely. Children of these rejuvenated moguls are now hiring their own lawyers to intervene in their parents' divorces, seeking to protect their expectancy interests in estates that may now last for a century or more. The New York divorce lawyer is now representing 3 generations of a family in a single matrimonial action. This brings us to the ultimate question. If the law can no longer rely on the natural end of a life to settle a contract, does the eternal prenup become a necessity for social stability? We are seeing the first drafts of agreements that are designed to last for 100 years, with re-indexing periods every 25 years. These documents are the most complex financial and personal instruments ever created, involving multi-generational trusts, international jurisdictional hedges, and biological contingencies. As we move into the final part of our deep dive, we will see how the New York divorce lawyer, once a seeker of fault in hotel rooms, is now the architect of the century contract. We will reveal the one clause that is being debated in the New York State Senate right now that could make it illegal to divorce a spouse who has not also been given access to the same longevity treatments as the moneyed partner. The biological equality mandate is the final frontier. How will the most powerful lawyers in the world handle a law that requires them to share not just their client's money, but their client's very survival? The finale of this masterclass will reveal the endgame of the biolegal revolution and the final evolution of the New York divorce lawyer into something far more powerful than a legal advocate. The era of the legal immortal is here. The biological equality mandate is the final, most complex transformation in the long history of New York matrimonial law. As we sit here in 2026, the New York State Senate is debating a piece of legislation that would have sounded like science fiction to the lawyers of the 1787 adultery-only era. This proposed amendment to the domestic relations law suggests that longevity treatments, once considered a luxury health expenditure, should be classified as a non-reducible marital right. In the hands of a 2026 New York divorce lawyer, this means that if one spouse has utilized marital funds to extend their biological lifespan, the court may mandate that the other spouse be provided with the same financial resources to achieve biological parity. This is the endgame of equitable distribution, the distribution of time itself. Imagine a character named Jonathan, a billionaire venture capitalist who has undergone high-level cellular regeneration. His wife Sarah has not. As they enter a divorce, Sarah's lawyer isn't just asking for the penthouse and the private jet. They are filing for a biological equalization award. The argument is profound. By allowing Jonathan to exit the marriage with a biological age of 35 while Sarah remains at 60, the court would be sanctioning a fundamental inequality that exceeds any financial disparity. Sarah's lawyer presents a step-by-step cost analysis of the treatments Jonathan received, arguing that Sarah's contribution to the marriage entitles her to the same future life that Jonathan has secured for himself. The potential outcomes of these cases are creating a new class of legal practitioners, the bio-legacy architects. These lawyers no longer just draft papers. They coordinate with longevity clinics and actuarial scientists to build what is being called the century contract. This is a legal instrument designed to govern a partnership that may span 150 years or more. These contracts include mandatory reindexing periods where, every 25 years, the couple must undergo a full financial and biological audit. If the biological gap between the spouses exceeds a certain threshold, the contract triggers an automatic transfer of wealth to allow the less rejuvenated spouse to catch up. Historical trends show that New York has always been the laboratory for high-stakes social changes in the United States, and the biolegal revolution is no different. The 2010 move to no-fault divorce was the catalyst for removing morality from the equation, and the 2026 biological equality mandate is the catalyst for removing natural decay from the equation. The New York divorce lawyer has evolved from a seeker of moral fault to a manager of economic assets, and finally, to a curator of human existence. They are now the legal immortals, drafting documents that will outlive the very judges who sign them. But the complexity of these 2026 century contracts introduces a new type of litigation, the permanence challenge. Lawyers are now arguing over whether a person has the legal capacity to bind their future self for 100 years. If Jonathan signs a contract in 2026 that governs his assets until 2126, can his 2076 self, who may have entirely different cognitive and emotional profiles due to advanced neuroregeneration, claim that the original Jonathan was a different legal entity? This is the ship of Theseus paradox applied to the Manhattan elite. Step by step, the lawyer must build a continuity of self dossier, using digital logs and neural backups to prove that the person standing in court is the same legal party who signed the agreement decades prior. We are also seeing the rise of the post-biological asset. In 2026, many high-net-worth New Yorkers are investing in digital consciousness legacies, AI models trained on their own speech patterns, memories, and decision-making processes. In a divorce, who owns the AI version of the spouse? If the AI can continue to manage a hedge fund or produce intellectual property, is that AI a marital asset? The New York lawyer is now litigating over the ownership of a personality. Case studies from this year show that these digital twins are being treated as enhanced earning capacity assets, similar to the medical licenses of the 1980s, but with an infinite shelf life. This leads to the final evolution of the attorney, the jurisdictional ghost. Because these biological and digital assets often exist outside of traditional physical boundaries, the 2026 lawyer must be a master of international data havens. They are creating sovereign family offices that move a couple's legal center of gravity to decentralized jurisdictions if the New York courts become too restrictive. This is a game of high-stakes hide-and-seek where the assets being hidden are not just millions of dollars, but the very code and biological data that define the family's future. However, the social stability argument is the final check on this power. The New York bar is beginning to see a counter-movement that seeks to limit the length of matrimonial contracts to a human generation, perhaps 40 years. These advocates argue that the legal immortal model creates a static, neo-feudal society where wealth and life are locked away forever by a single generation of lawyers and their clients. The 2026 courtroom is becoming a battleground between those who want the freedom of the bioreset and those who want to maintain the natural cycle of wealth transfer and social mobility. Consider the case study of a major New York political dynasty. Their lawyers have drafted an eternal postnup that governs the family's assets across 5 generations of potential rejuvenated heirs. The state is challenging this under the rule against perpetuities, an ancient legal doctrine that prevents property from being tied up forever. The New York divorce lawyer is currently attempting to modernize this doctrine, arguing that if the person is still alive due to longevity science, the rule should not apply. It is a fundamental rewriting of the foundations of Western law. As we conclude this deep dive masterclass, we see that the history of the New York divorce lawyer is the history of New York itself. A relentless pursuit of the new, a total disregard for the status quo, and an obsession with the valuation of the intangible. We have moved from the holy deadlock of the 19th century to the biological equality of the 21st. The lawyer is no longer just a representative. They are the architects of a new human condition. But even with all this technology and law, one question remains. Can a contract ever truly capture the essence of a human relationship? As we look toward the 2030s, the unquantifiable clause is becoming the newest trend. A deliberate legal gap left in these massive contracts to allow for the one thing an algorithm cannot predict: a change of heart. The elite New York firms are now charging a premium for human error protection, acknowledging that even a rejuvenated billionaire is still subject to the oldest fault of all: the unpredictability of love. If you thought the hotel room raid was the peak of divorce drama, you are now entering a world where the drama is written in the very DNA of the participants. The history of the New York divorce lawyer is not over. It is simply resetting for a much longer, more complex second act. The legal immortal has just begun their practice, and the first century-long trial is about to commence. While the era of the biological reset has changed the math, the search for a fair exit remains the driving force of the Manhattan legal machine. The next decade will determine if these eternal contracts can survive the test of time, or if the unquantifiable clause will be the loophole that brings the entire system down.